Punjab, it's a huge battle between Twitter and the government of India, with Twitter filing a writ against the government, saying that there are arbid requests from the government of India on taking down accounts of individuals on Twitter. So Twitter has taken the centre to court over content blocking orders. There's a legal fight over the government's content blocking orders. Now, the writ, as I mentioned, has been filed in the Karnataka High Court. Sources tell us, Twitter says, sources close in fact to the filing say that some blocking orders are arbitrary and disproportionate. Again, those close to that filing tell us that some orders didn't give notice to content originators. Twitter says that the government sought blocking of some content by political parties' handles. Again, those who've sort of got information about that filing, they have to say this as well, and that's a very significant point. Are the views of political parties on their official party handles being suppressed by the government? Sources say that Twitter believes that blocking political content violates the freedom of speech. Sources say that Twitter says they remain committed to the principles of openness, transparency, and that they seek a judicial review of content that the government wanted blocked. Very, very significantly, there's a big difference between the blocking of tweets when ordered and the blocking of accounts. And sources close to that filing have told us that Twitter is particularly concerned over several orders asking for account level blocking. That is an altogether different blocking level and something which is done in the very last instance, as it were. But that's what the request is. So the big question then is, what about what the government has told Twitter, that look, you have to follow the IT regulations and you have to ensure that whatever we want blocked has to be blocked. That's now all gone to the High Court. Will the Karnataka High Court, for starters, be actually deciding what should be blocked and what should not be blocked?
देखो, सोशल मीडिया एक बहुत ही पावरफुल मीडियम है. सोशल मीडिया का हमारी लाइफ में आज बहुत बड़ा प्रभाव है. इसकी अकाउंटेबिलिटी कैसे हो, ये क्वेश्चन दुनिया में सब जगह अभी एक बहुत ही वैलिड क्वेश्चन बन चुका है. और दुनिया भर में देश और सोसाइटीज इस डायरेक्शन में मूव कर रही है कि सोशल मीडिया को अकाउंटेबल करना ज़रूरी है. कैसे अकाउंटेबल करें? सबसे पहले सेल्फ रेगुलेशन. किस तरह से खुद ही कुछ ऐसे कंटेंट, जिन कंटेंट से सोसाइटी में एक हार्मफुल इम्पैक्ट आता है, उसको खुद ही दूर करें. फिर इंडस्ट्री रेगुलेशन, फिर गवर्नमेंट रेगुलेशन.
Well, Sunil Prabhu has been tracking the story very, very closely. He joins us now. So, Sunil, with this now being a sub judice matter, is Twitter for the moment protected against, for example, being in violation of guidelines, as an intermediary?
Well, they have been as you rightly pointed out, been arguing this point for a continuous basis, and of course this is now subject to judicial review, which the courts are already have entertained this case and are already looking at it. The government, of course, keen to ensure that the rules are implemented, wanting certain safeguards to take place. This is, and Twitter is not alone. There are others who have also been part of this process in terms of intermediaries who have had concerns over the rules that have been put out. We'll have to wait because this is a question which, as you rightly pointed, is sub judice. But definitely the government had come out with another bill subsequently, which was passed in the Lok Sabha, in the Rajya Sabha. It had gone to a select committee. They wanted to tweak further those amendments. But in a select committee, you can't really do too much of tweaking because you can only deal with the basic content and the select committee can give, but you can't really, the government can't bring in official amendments on its own. So there have been to and fro in this entire process. What exactly is the tweaking that the government wanted to do to send that message across not only to Twitter but other intermediaries who would be considered as intermediaries? It's in that context that we'll have to wait. But definitely the government had ensured and had mentioned earlier, which I think the minister, as well as of course the junior minister is referring to, while they welcome them, certain laws have to be followed, but they're not talking about the fact that they themselves had planned official amendments to the bill to ensure a little better compliance, because they all agreed that the rules needed certain tweaking.
All right. Thanks very much for sharing those details with us. Thanks very much indeed. Well, joining us now, N.S. Napinai, advocate in Supreme Court of the Supreme Court and founder of Cyber Sathi Foundation. Thanks very much for being with us. Is this, the bottom line? Shubhimal Bhattacharjee, a cybersecurity expert, also joins us. But Ms. Napinai, let me come to you. Is this where this was always headed? Because Twitter has, for a period of time, it is believed, had serious concerns about the freedom of expression and requests from the government for account level blocking. So was it almost inevitable that this would end up in a court?
Well, it was open for Twitter to contest every single order that was given to it by the government for a takedown. And you don't have a choice. If you have a problem with a takedown order or a blocking order, your only option is either to comply with it or to go to court and seek a judicial review. Because only with a court's order of stay or an order in your favor could you then desist from complying with the government's order.
Right.
By yourself, you cannot take a decision as a supra-sovereign or a supranational to say that I will take a subjective call on whether I want to comply with a particular order or not. If Twitter were to take that kind of a decision, then they ran the risk, and they continue to, in fact, now run the risk of losing their safe harbor provision. So it was always open to Twitter to go to court. But the way in which they've gone appears to be a little unsustainable, because they seem to be asking for blanket orders, saying that there are many blocking orders which are unsustainable or excessive, etc. You can ask for individual orders, individual government orders to be reviewed. But to ask for a blanket relief may not be sustainable, because
let me just go across very briefly.
You're questioning the wires of Section 69A itself, which has been upheld by the Supreme Court.
Right. I just wanted to go across to Mr. Bhattacharjee. Sir, the larger issue over here is that Twitter has had, let's face it, a pretty awful equation with the government of India. Just a couple of instances of this. Twitter removing the verified badge from the Vice President's handle last year, Venkaiah Naidu. That was then restored. The Twitter office was raided by the police last year in May. Right, they were served a notice in connection with their probe into the controversial toolkit case, as it were. They marked Sambit Patra, the BJP spokesperson's tweet, as manipulated media. The Twitter founder, Jack Dorsey, had sort of liked tweets which supported protesting farmers as well. So, there's Twitter, which on the one hand believes in the freedom of expression for right and for wrong in certain cases, versus the government which says that, it's our political agenda which needs to be endorsed one way or the other. Isn't that what the core of the battle is?
Well, the core of the battle, Vishnu, is very clear that there are rules and laws laid down, and on the basis of which the government is seeking the removal of certain contents from Twitter. Now, very many times, you might agree, you might not agree with what the government is asking. And by and large, Twitter has to follow the way the licensing rules are and what, how their intermediary provisions as per the law are, or as per the IT Act, as well as the rules are. You have seen that, Twitter has been recalcitrant. There were all these time since last year, when the implementation of the IT rules 2001 had started.
No, but Mr. Bhattacharjee, the point is that, and I've spoken to, in just the last little while, to to individuals close to the filing itself in the Karnataka High Court, and it's not just a question of Twitter not wanting to follow orders or Twitter refusing to sort of block sites or not sites but handles. They are basically saying that what the government is doing is overboard and arbitrary. They don't necessarily provide notices to the originators of the content. The action being sought by the government is disproportionate. They want account level blocking very often as opposed to tweet level blocking. And I think this is most significant at one level. Several of these orders pertain to political content that is posted by official handles of political parties. So, I mean, if rival political parties say something and you say take it down, then what does that mean? You're trying to dominate what exists on Twitter. You can't do that.
Well, Vishnu, in many cases, Vishnu, what has happened is that Twitter hasn't remained as a platform. It itself tries to become an editor, and that's where the problem lies. But they've done a good thing if they are looking at a judicial review of the individual cases that come in hand. I'm sure that will settle the matter once and for all. But it's a very complicated area. Generally, the best method would have been to find a working arrangement between the platforms and the government.
No, but I think, Ms. Napinai, the allegations, and this again, sources close to the writ who I've spoken to, so this I would suggest is essentially what the writ is all about. This is damning and this is damaging. If these allegations, and obviously the court has to look into it. Blocking political content, which is of political parties, and blocking information is a violation of the freedom of speech guaranteed to citizen users of this platform. And the content at issue does not have any apparent proximate relationship to the grounds under Section 69A. In other words, it's random requests for blocking. It's not just
Vishnu,
Twitter not following the rules, it's the government being big brother, if not dictator.
Yeah. Vishnu, this is precisely why I said that in each of these instances which Twitter is raising this accusation about, it was open to them to go to court saying this is in violation of Section 69A's parameters. X is in violation of the constitutionality mandate as has been laid down by the Supreme Court, whilst recognizing Section 69 to be to be sustainable as a constitutionally supported provision, etc. So that can be done only with respect to each order, which has to be evaluated on its merit separately.
Right.
You cannot go for a blanket order, because what exactly can a court say? Can it say that yes, government has been excessive, so it should act well within its order? Can it say that I will put a blanket stay on the use of Section 69A? In effect, by saying that, Karnataka High Court will then have to overturn the decision of the Supreme Court in Shreya Singh's case, where the constitutionality of the provision was upheld. That is not feasible in law. So you have to seek a remedy for which there is a right.
Because the Supreme Court cannot look at hundreds of cases.
Whose content was to be taken
the Supreme Court cannot look at hundreds of orders and judge them.
Twitter could have approached the court.
Yeah. No, it is complicated because the Supreme Court cannot be judging hundreds, and this number is off the top of my head. We don't know the numbers. I would assume that they are very substantial. However, Mr. Bhattacharjee, here are some of the other concerns which, again, sources close to this filing have told me that several blocking orders issued to Twitter only cite the grounds of Section 69A, but fail to demonstrate how the content falls within those grounds or how the said content is violative of Section 69A. In other words, disproportionate use of power.
Vishnu, once again, when a request goes under Section 69A, before that there is also a process. The process is followed only then a request goes. Now the question is, whatever request goes, is it tenable under law, and if at all, something excess has been sought. Under the current set of rules, Twitter has to comply with whatever direction goes from the government, and this time again, they have complied with. But the larger question that remains, that you are also harping on is that whatever is going as a request under Section 69A, are they in violation of free speech anywhere at some stage?
Right.
So I think since this has become complicated and all, and they are going to the court, let the court take a call. Even if in one instance the court takes a call and says that this has been bad in law and it's something that that couldn't have been asked. I think that will send us also a message for many other cases, and possibly a way and means to understand about if some of the rules,
right. I get that point,
changed.
and I think questions would also need to be asked about whether Twitter itself is doing enough to get rid of a lot of the online hate that we see from any number of individuals. Doesn't Twitter need to do more about that? I think that question also needs to be asked. We'll take a short break. I'd like to thank you both very much for joining us.